Hello and welcome to Legal Thinking. I'm Liam Pape, and that is usually where my dear friend and co-host Ed Wotton would usually chip in, but he's away for a few weeks, so I'm left here all by myself. Alas, he'll be back soon. We start off today's episode with a letter from a Mr. Paddy or Furniture. He writes, Dear Legal Thinking, first-time listener, long-time writer, I'd just like to say how much I enjoy the insight and expertise of your host Liam Pape. I think his dulcet northern tones, mixed with an interrogative yet non-confrontational interview style, is something that many from the TV news can learn from. I've heard he's dashingly good-looking too. Hold on, it goes on like this for a few pages. Exceeding professionalism, yada yada yada. Should be the next James Bond. Here we go. He writes, I also have a question. I've developed a machine that can help you quickly and efficiently clean garden patios, but I don't know anything about how to trademark or patent the design or idea, or even what intellectual property rights are. Please help. Well, Mr. O Furniture, we've recorded an interview just for you. I'm joined by IP lawyers from RWK Goodman, Charlotte Ebbutt and Stephen Welfare. Earlier this year, Charlie Ebbutt and Stephen Welfare attended the National Association of Jewellers Awards and presented the prestigious Designer of the Year Award, which RWK Goodman was a proud sponsor of. This award was a perfect fit for RWK Goodman because they operate the Copywatch scheme for the NAJ and have done so for over 25 years. So Stephen, can you explain a little bit about what the Copywatch scheme is?
Copywatch, it's a bespoke intellectual property advice and protection service which is offered by the NAJ, and I should add also other member organisations within the Allied Trades Federation, which is a combination of trade bodies, to its members, to their various members, entitling them to intellectual property advice, which they receive from both ourselves and also from trademark attorneys.
And for complete clarity, what is meant when you talk about intellectual property?
Yeah, it's got, I should add, nothing to do with clever real estate. Intellectual property here is the collection of intangible property rights, wherein various rights such as copyright and trademark are exercised by those owners. So there can be various associated rights, such as passing off confidential information, trade secrets. All of these things are part of that collection of intellectual property rights.
And under the Copywatch scheme, lawyers, including yourself, Stephen, and Charlotte, attend major trade shows at the Birmingham NEC and in London to offer on-the-spot advice to NAJ members who are exhibiting or visiting. Apparently, this can lead to some interesting or, on occasion, some bizarre queries.
So it's not uncommon when you're walking around at these trade shows to see suspiciously similar products on different stands, and I'm sure Stephen can attest to this over his years of attending. I think the most bizarre or sort of oddest product that I was ever asked to give some advice on the spot was a range of knuckle dusters that had been created by one of the exhibitors there, and they were asking whether it would be possible to protect them as registered designs. But yeah, not the most usual product, but certainly an interesting one to look at.
And Stephen,
Oh, so many, more than we've got time to list, I dare say. But following on from Charlie's reference to knuckle dusters, probably the most infamous occasion at a trade show was where a client of ours alleged that somebody else had a knockoff of one of his products on his stand and wanted immediate action. But before my colleague and I were able to intervene, he took the law into his own hands, stormed on to the other chap's stand, confronted him, and it kicked off with punches being thrown, resulting in my colleague and I having to separate the combatants. And I had to then keep my client literally with his head down, to avoid the security services and the police. So when they turned up, everything was calm and serene. So it sounds like it's a very violent place of knuckle dusters and fistfights, but 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 it isn't. It's, they were but exceptional cases. Yeah.
So it sounds like you're really going the extra mile there for your client as well, Stephen, by protecting them from physical altercations.
Yeah. I should have charged danger money, but no. Normally it's much more simple and boring. But there we are.
Got it. So down to business, Stephen. What are intellectual property rights?
Yeah. So the main intellectual property rights, registered rights, are patents, registered design and trademarks. The unregistered rights are copyright and unregistered design rights. The associated rights, as I mentioned earlier, are things like passing off and confidential information, trade secrets, and so forth.
And Charlie, can you talk a little bit more about trademarks?
Yes, of course. Well, trademarks are a huge topic in their own right, and I could probably do an entire podcast just on trademarks. But I'll try and keep this relatively brief. So, a trademark in its simplest form is a sign which is used by a trader to differentiate its goods from those of other traders. And if you think about a brand, sort of in olden times, this was developed out of farmers and herders literally branding their animals with a mark to show that the animals belong to them. And whilst it's become rather more sophisticated since then, essentially a trademark is used to communicate where a product or a service has come from. And a trademark can take many forms. It can be, words, so a brand name. It can be a slogan, a design or a logo, domain names, shape of goods and packaging can be a trademark, as can more unusual things such as smells, sounds, colors, and even some moving digital images. These can all function as a trademark. And as Stephen said earlier, trademarks can be registered. They can also be unregistered. But the benefit of having a registered trademark is that it gives the owner the right to exclusive use of that mark in connection with the goods and services for which it's registered. And that means that you have the right to sue anyone who uses an identical or similar trademark in connection with similar or identical goods and services as you. And in the UK, a registered trademark can last indefinitely, provided that it's renewed every 10 years. And trademarks can be really valuable assets. And we saw in 2021 that ASOS paid, I think it was £265 million for the Topshop, Topman, and Miss Selfridge brands. And also, trademarks are really interesting because they're sort of around us all the time. There are trademark disputes going on all the time. So at the moment, and this is relevant to the cost of living crisis, you might have seen recently in the news about the dispute between Lidl and Tesco, whereby Lidl have alleged that Tesco's use of its club card logo, so the blue square with the yellow circle, infringes various Lidl trademarks, and that's going to go to trial next year. So and we've seen over the years all sorts of different famous trademark cases from Christian Louboutin's red soled shoes to Colin the Caterpillar, all sorts of cases in the news and that are really interesting. So yeah, trademarks are great.
You mentioned there that trademarks can be a registered right. What are the other types of registered rights?
Yeah, so as Stephen said, IP rights fall into two general categories. You've got registered rights and unregistered rights. Registered rights are granted basically once you've applied to an official body, and in the UK, that's the UK Intellectual Property Office. And aside from trademarks, the other registered rights are patents and registered designs.
Aha, patents. So, on patents, what is a patent? And is it patent or is it patent? And if you want to explain a little bit about novelty as well.
Well, I'll probably answer that one as patent is the most ancient of the rights, and obviously, therefore, I'm instantly more qualified to talk about that than Charlotte, as I am the more ancient of us. But so it dates right back to the royal prerogative, and rights were granted monopoly rights to inventions by the use of the royal prerogative through what was called letters patent. So it doesn't matter whether you refer to the right as a patent or a patent. Lawyers and attorneys refer to the grant of a patent, but as I say, it comes initially from the grant of letters patent. So it's not incorrect to refer to it as a patent. A patent is a registered right, and once registered, it grants to the owner a monopoly of 20 years during which that owner can exploit it. It's there to protect industrial inventions. To qualify for a grant of patent, the invention must be novel, which we understand to be new. It must involve an inventive step. And thirdly, it must be capable of industrial application, which, to put another way, means ideas, notions, and even discoveries themselves are not patentable unless and until they are embodied in an article or a process that is capable of business exploitation. A novelty means that it must be new. So when filing the grant of patent, the invention must be new. Well, what does that mean? Well, it means that it must not already be known to the public. That's what we call being part of the prior art. If any details of the invention can be found in the prior art, then the application will fail. The public here is the world at large, not just the UK. So it's imperative that the details of the invention are kept secret until after the application has been filed. Some examples of the sort of things that are capable of a grant of patent are all sorts of mechanical devices, and that could be something as simple as a mousetrap. It covers methods for doing things, such as the methods for dyeing or bleaching of fabrics. It can cover chemical compounds, for example, a new drug, and this is perhaps the most used area for patents these days, as certainly can lead to a lot of litigation. And also, it includes mixtures of compounds, for example, hand creams.
What unusual products or inventions have been granted a patent?
I can't say whether all of these weird and wacky applications ended up being granted, but you can access applications themselves in the IPO website, and they are indeed quite weird and wacky. And some, I'll give you three examples. One was for an adult advent calendar. Sounds innocent enough by itself, but it consisted of 25 windows, like your ordinary chocolate calendar. But in this case, behind each window were different condoms with a sexual position that you could presumably try out. As I say, no idea how far that got.
Merry Christmas.
Yeah, Merry Christmas indeed. Another application. This is almost unbelievable. Was for a spider ladder. Yes, literally a little latex ladder which you could put into your bath to help the spider climb out of the sink.
Excellent.
And perhaps one more is a portable seat. This is well, it would have been if it had gone into production. a padded seat which you strap around your waist. So when you get the need to sit down, you can sit down anywhere, and you've immediately got attached to yourself a nice cushioned seat, which is actually pivotable.
It sounds very convenient, if not, maybe not very fashionable, to be honest with you.
Convenient seat indeed, yes.
So, Charlie, can you explain a little bit more about registered designs? What are they and how are they obtained, and what is the period of protection?
So a registered design is also a monopoly right, which gives the owner the exclusive right to make articles that incorporate that design. So registered designs can protect the appearance of three-dimensional and some two-dimensional products or parts of products and designs. It's quite interesting to note that there is no requirement for the design to have any artistic merit. However, it must meet certain criteria to qualify for protection. So the design must be new, and similarly to a patent, it means that an identical design must not have been made available to the public anywhere in the world before the application is made. However, the designer does get a grace period of 12 months after the first disclosure of the design in which to file the application. So all is not lost if you have disclosed it, but you need to get the application in within 12 months. The design must also have what's called individual character, and this means that it must give a different overall impression from any other previous designs that are already out there. And thirdly, it mustn't fall into one of the specific exclusions which are set out in the legislation. And these include things like computer programs, designs for products which are dictated solely by their technical function, things like royal arms and coats of arms, and other specifically controlled symbols, such as Olympic rings and things like that. And a registered design lasts for a total of 25 years, but you need to ensure that it's renewed every 5 years in order to keep it in force.
Charlie and Stephen, thank you very much for your time. Thank you for listening to this episode of Legal Thinking. We didn't touch upon copyright and unregistered rights, which is a huge topic in amongst itself, so maybe Charlotte and Stephen can come on again to discuss that. If you feel like you've got an invention that could benefit from patent protection or advice, then our advice is to go see a patent attorney first before speaking to anyone else. Stephen Welfare, who we spoke to in this episode, represents clients in patent disputes, but at RWK Goodman they don't prepare and file applications. But they do file trademark and design applications and can otherwise service all your intellectual property needs. All the previous episodes of Legal Thinking can be found wherever you listen to your podcasts. Do make sure you leave a 5-star review on your podcast listener of choice. And I'll see you next week. Will Ed Wootton be back? Listen to find out.